Hello, and welcome to the January 2018 episode of Lunch with a Lawyer. I'm Steve Richardson, and we're going to talk this month about basically how you can get into trouble in New Jersey for some minor criminal matters or traffic violations that can lead to jail time. I've been in court where the clients have pled guilty and the police officer comes up, puts the cuffs on, and leaves them off to jail. And nobody wants that. So what we're going to talk about is, in general, some of the common traffic violations and minor criminal offenses that can involve jail time and put you at risk of incarceration, along with some alternatives to jail time, just sitting in a jail cell, as well as a couple of options for avoiding conviction and the attendant jail time altogether. So we'll get into that in a step-by-step thing. But first thing, let's talk about how you can get into trouble. Now, you've seen on TV these terms, felonies and misdemeanors. Well, in New Jersey, we don't have felonies and misdemeanors. We have, instead of misdemeanors, we have disorderly persons offenses and petty disorderly persons offenses. Those are handled at the municipal court level, traffic court. And then we have indictable offenses that are handled at the county level by county superior court judges and county prosecutors. So what I'm talking about here are the equivalent of misdemeanors and traffic court offenses that can lead to incarceration, to jail time. For example, disorderly persons offenses. These can include shoplifting, assuming you didn't steal something of significant value from a place. It was a minor theft of a fairly low value that would make it a disorderly persons offense. Shoplifting, simple assault, things like that, but minor crimes. Also in traffic court, if you've been convicted more than once of driving on a suspended license, possession of drug paraphernalia, maybe you have a roach clip or a water pipe, something like that is used for the ingestion or use of illegal drugs, a hypodermic needle, things like that. Leaving the scene of an accident. That is serious. You get into an accident and you don't stick around, you leave. That, if there's no personal injury, that could be 30 days in jail. And what's worse, if there is personal injury, if someone was hurt and you left the scene, 180 days in jail. So it can be serious. Driving without insurance, auto insurance, a second or subsequent offense for that can lead to jail time. Possession of drugs, we'll get into that. This is possession of drugs for the intent of personal use, not so much of a particular drug, and we're talking about marijuana here, really. Not heroin or things like that. That's not handled at the local level. That's county. That's indictable. But possession of marijuana, reckless driving can sometimes lead to jail time if it's serious enough. Or unlicensed driver. Now, unlicensed driver is different than driving while suspended. This is where you have never been licensed to drive a car. You go around and say, don't have my license. You go around joyriding. And usually the first offense is no incarceration. But after that, you can be facing, if you do it repeatedly, can result in jail time and maybe permanent ban from ever having a New Jersey driver's license. So there can be some significant consequences to that. So that gives you an idea of the type of trouble you can get in local court, in municipal court, traffic court, and where you could end up in jail. There are some more offenses where jail isn't mandatory. It may be a range of 0 to 10 days, 0 to 15 days, things like that, where there oftentimes isn't a presumption of incarceration, or the judge is not required at all to give you any jail time. He can choose not to, he or she. But these are the most common ones. So let's first talk about alternatives to jail. Now, whether these alternatives are available to you can vary from county to county, sometimes to judge. It can depend on the type of charge. But the first alternative is called the Sheriff's Labor Assistance Program, otherwise known as the SLAP program. I write about this on my website. There's a fair amount of traffic there. People are interested in it. People sometimes will call me about the SLAP program. But it's basically a work release program. You agree to do certain work instead of sitting in a jail cell, which is certainly preferable. Now, it's a community-based corrections program, where you do manual labor instead of going to jail. This keeps you from losing your job, jeopardizing your family's financial future, things like that. So if you can get into the SLAP program, it's good. Now, not everyone gets into SLAP, okay? This is a discretionary thing. It's run by the county sheriff's department, and this is for minor offenders with minimal or no risk to the public. Okay, so this isn't a violent crime. You're not a danger to the public. Your criminal history will be checked. All right, as part of, if you apply for the SLAP program, and they'll look into you. If you're found to have a criminal history that contains a violent crime, drug distribution, certain sexual offenses, you're not going to get in. Okay. Now, if you do get in, all right, you're required to follow all the rules and regulations. And if you don't do that, you'll be revoked from the SLAP program and ended up serving your term in jail. The remainder of your sentence, you would get credit for the time that you did do it and participate in the program. What type of labor is involved? Not heavy labor. I mean, it's not hard labor. You see guys breaking rocks with picks, no. But more like you see people on the side of the road picking up trash. You can work at, for example, at a municipal recycling center. As I said, municipal road cleanup, some painting and landscaping work for the municipality, things like that. So what happens is, and usually with the assistance of a lawyer, as part of the, if you enter a guilty plea as part of the sentencing phase, you apply to the judge and say, look, Your Honor, do you have any, you're sentenced to jail time, do you have any objection to it being served through the SLAP program? If the judge says, no, that's fine, that's up to the sheriff. You can apply separately to the SLAP program. Very often the judge will give you the opportunity to give a future report date or something like that, give you time to apply to the SLAP program, not send you directly to jail. But then you have to pass muster with the sheriff's department. As I said, they'll do a background check, they'll look into you, make sure you qualify. So that's something that the judge would have to approve, and then you apply separately for with the sheriff's department. Another thing is house arrest. This is, you wear basically an ankle bracelet. That is, you cannot go a certain distance from a certain GPS point. You may be allowed to go back and forth to work, but what you can do is limited. Your home or your job is your jail cell. Again, this is something that you would apply for through the judge, say, do you have an objection to the anklet program? And then it's done, you apply through the sheriff's department for that program. And again, the judge would give you a future reporting date, give you an opportunity to apply for the program, see if you can get in and do house arrest. And again, it can depend upon the charges, it can depend upon the judge, etc. The third alternative to incarceration is to serve it on weekends. Instead of just being straight time, for example, an enhanced driving while suspended could end up with a 10-day jail sentence. Instead of doing 10 days straight, you do 5 weekends. Now, I see we have someone who's joined us. Please, since someone has, please comment on the video. Let us know you're here. And even more so, if you have a question about this stuff, post a comment, post a question. I'll try and answer it. With weekends, it can depend upon, again, the county sheriff's department. For example, my practice is here in Woodbury, which is the county seat for Gloucester County. I had a case in a local township where we talked about serving it on weekends. And the judge said, well, I don't have an objection to weekends as long as the sheriff's department can handle it. So he gave me a continuance of the case before actually entering a plea, and gave me the opportunity to reach out to the sheriff's department and said, look, can my guys serve a term on weekends? Unfortunately, I was told no. They, at this time, with the population of the jail, et cetera, they simply don't have the manpower ability to administer someone coming in for the weekend and serving out a term that isn't just straight time, comes in, stays, and then leaves. Now, whether this will continue in Gloucester County or not, I don't know. It may just be a temporary situation, but it was a problem at the time. So even if the judge approves it, again, it has to go to the county sheriff and then make sure that they can do it. Some offenses, there's really they won't allow the ankle bracelet or SLAP program for something like an enhanced driving while suspended. Now, what does that mean? Well, if you were driving on a suspended license and your license was suspended because of drunk driving, then there are enhanced penalties. You can go and serve a lot more time. For example, ordinarily, if you had a third or subsequent offense for driving while suspended, you could be facing 10 days in jail. Well, if it's enhanced, it could be 10 to 90 days in jail, on top of the 10 days base for the conviction. Hi, Teresa. How are you? How are things in Texas? Thanks for joining us. So that, and if there are certain circumstances where the enhancement is actually a fourth-degree crime, considered a felony, not a traffic court violation, and it could be even worse than that. It could be 6 to 18 months in jail for this. And they really don't allow you to serve through SLAP or the house arrest program. Now that, again, can depend upon the county. In New Jersey, the prosecutor, the judge. I'm not saying, take that off the table if you find yourself in this situation in New Jersey, but certainly be aware that it may not be available. So because I'm talking about it, don't expect that you'll be able to get in. For a third or subsequent conviction for drunk driving, for example, that involves 6 months in jail, and the best you can do is serve up to half of that in a rehab program. And oftentimes the judge will require the jail time half to be served first, and then you go to rehab. Thanks for the like. Appreciate that. And certainly, and that reminds you, if you like what you're seeing, please like or love, or just click that button there. It helps with the sharing, helps people find the show. And if you really like it, hey, share it on your timeline. Share it with other people. So there may be some unavailability for those alternatives. Now that's how to stay out of jail once you've been convicted. There are a couple programs where you can avoid conviction entirely of something that involves jail time. There is a program called conditional discharge. Now, this is a program for offenses that involve possession of drugs. We talked earlier about possession of a small amount of marijuana. That's for personal use. And what you can do is, and this is a one-time thing, where you can dodge the bullet and get out of going to jail, and the other consequences of possession of the drug, is you go into the conditional discharge program. If you're convicted of drug possession, not only jail time, but license suspension, some really hefty fines. You're really avoiding all of it not just the jail time, but you're also avoiding the license suspension, the fines, everything else, because you're not being found guilty, you're not pleading guilty. This is simply a what's called a diversionary program. It's for your first time brush with the law. You can get into the program if the judge determines that your continued presence in the community or in a civil treatment center or program will not pose a danger to the community. Well, again, that's like with SLAPP we talked about. You're not a danger. You're a drug user. You smoke pot, but you're really not a danger to the community. And that if you seek treatment or to address your problem, then that's really the better solution to being put in jail. Hi, Gail. How you doing? How are things in California? Thanks for joining. So that's the first thing. The second is that the terms and conditions of supervisory treatment will be adequate to protect the public and will benefit you by serving to correct any dependence on or use of controlled substances which you may have. So you're not a threat to the public, and this may help you get into a treatment program and again solve the problem so you can get on with your life. So if you meet these requirements, the judge will then suspend the proceedings and place you under, the statute says, place you under supervisory treatment upon such reasonable terms and conditions as it may require. Now what usually happens is they will sentence you to a 1-year period of time during which there can be random drug testing. And during that period of time, you must pass any random drug test and you must stay out of trouble. All right. If you end up getting into trouble again, that could violate your conditional discharge. You end up back in court, and you could end up in jail again. License suspension, heavy fines. There could be, you could have problems getting public employment, all sorts of problems as a result of a drug conviction. So that's good. So now you also want to be aware you don't want to plead guilty. Okay. Strictly speaking, if you plead guilty, then your license can be suspended, even though you're in a conditional discharge program. So that's just something to be aware of, and a sort of a trap that you don't want to fall into. And even then, with license suspension, there is a hardship exception. Unlike drunk driving, where your license is suspended and they don't care whether you can't get to work as a result. If a suspension of your license will cause a real financial hardship, the judge can waive suspension of your license, in this case with a drug charge. Now, the other way of dodging the bullet, and by the way, if you get to the end of that 1-year period of time and everything is fine, then the charge will be dismissed. So there's no conviction on your record. Now, there'll still be an arrest, but you can seek to have that arrest expunged from your record. All right. So this is a good thing. So that's for a drug charge with conditional discharge. Now there's something else called conditional dismissal. Now what that is, it started beginning of 2014, so it's fairly new. And there's for offenses classified as disorderly persons offenses or petty disorderly persons offenses. In other words, what we talked about earlier, what other states would call a misdemeanor. So you found guilty of a misdemeanor, or you're charged with a misdemeanor, you can use the conditional dismissal program in much the same way you do with conditional discharge to avoid being convicted of the crime as long as you basically behave yourself. So you can get into the program if you have no prior convictions. Okay, this is your first time brush with the law, and you don't have any previous conditional discharges, conditional dismissals, or at the county level with, as I said, with indictable offenses or felonies, you can have what's called a pretrial intervention. That's another what's called diversionary program for someone's first brush with the law. And finally, you have to have the approval of the court after your judicial evaluation. So the judge doesn't have to give this to you, but it is available to you. Now, in order to complete the program, you have to pay a $75 application fee, pay all costs, restitutions, and/or assessments levied by the court. For example, if you're charged with shoplifting, maybe some sort of restitution to the store of the value of the item, or return of the item, or some other things. You have no convictions or other offenses in any part of the United States. So if you got into trouble somewhere else, we talked about prior convictions. That's not New Jersey, that's anywhere in the United States. And finally, successful completion of any other program terms and conditions imposed by the judge. So same thing, you have a probationary period in which you have to be a good boy or girl and do everything you're told. And at the end of that time, if everything's fine, you won't get into trouble again, you don't violate, then the charges are dismissed, and at some point you can even seek to have the arrest expunged. So that helps as well. Now, bear in mind, as I said, this is a one-time thing. So with this, if you use it once, you can't use it again. So what I do, for example, with drug charges, I have clients that are eligible for conditional discharge, but I wait to see, well, does the state have all their proofs? Are they able to show that what they found is indeed drugs? Did they have a lab tested? Is there a lab report says that it is drugs? Can they prove their case? Sometimes, and I've had it happen, where they can't prove that, they can't get a report in time, and the case ultimately gets dismissed. So it ain't over till it's over. There is another way of doing it as well. You're talking about conditional dismissal, and I've done this. It's called dismissal with conditions. And there's a distinction. That is not a one-time thing like conditional dismissal. It's, we'll dismiss this case, but as long as you don't do something that you're not supposed to do. Oftentimes, for example, in shoplifting, don't go into the store again. Okay, they don't want to see you. They don't want you to be a customer. They'll agree that the charges can be dismissed as long as you don't go to that store again. So, again, if you're good, then fine. It's dismissed. You don't get into trouble. If you go in there again, you can be charged with trespassing. The old charge of shoplifting can be resurrected. So there is that one other way of getting off the hook, and I've been successful in doing that. And sometimes that can help if you're not eligible for a conditional dismissal. So you can get a dismissal with conditions. So that's it for this episode of Lunch with a Lawyer for January of 2018. I hope it was informative. Again, if you like the program, please hit that like button or the love button. Show me some love. Appreciate that. Helps people to find me on Facebook. And of course, this is going to be not only playable as a recording on Facebook, but I also release it to my YouTube channel. Thanks for the like again. Submit it to my YouTube channel as a regular video. You can subscribe to my YouTube channel and get those. So that helps as well. So you can catch it on the rebound on YouTube probably sometime next week. So that's it for Lunch with a Lawyer. If you have any, again, suggestions for future episodes, future topics, you can leave them in the comments. You can tweet them to @SJRLaw, and just let me know. And I'd be happy to, I'm always looking for new topics. We can put it on the schedule for future episodes. So, hit the like and love. Hit the share button. If you're watching this on YouTube, please feel free to subscribe as well. Other than that, I'll see you next month.